This is Talk Business and Politics with Roby Brock.
On Thursday, the U.S. Supreme Court ruled in favor of the federal government upholding the subsidies for certain health exchange participants as constitutional. In short, it preserves the Affordable Care Act, also known as Obamacare, much to the chagrin of the law's opponents. Joining me to dissect the court's opinion is former Arkansas Attorney General Dustin McDaniel, who dealt with a few challenges to the federal health care law during his time in office. Welcome, and tell everybody what you're doing now. What does a former Attorney General do?
Well, I practice law, which is certainly the most important thing that I'm doing.
It's more lucrative, isn't it?
It is, although you can leave the Attorney General's office needing a little refresher course on some of the basics. I know all of this law and everything from the environment to criminal law to agency law, et cetera. But I've always had lawyers to do some of the basic work for me for the last few years. So I'm having to bone up on some of the procedure.
It's good. Well, we're glad to have you with us, and thank you for all your contributions. You're going to be an ongoing analyst with us, and we appreciate that.
I'm excited to do it.
Let's talk about this Supreme Court decision. You describe it as a win-win-win scenario. Who's winning?
Well, it's kind of everybody is winning except for the plaintiff, Mr. King himself and his own attorneys. Obviously, it's a big win for the White House. The president, this was his signature domestic accomplishment in his time in the White House, and for the second time, a conservative Supreme Court has upheld it as constitutional. That's a big win. It's a big win for 16 million Americans that have insurance, that didn't have insurance, and would not have insurance but for the Affordable Health Care Act. But honestly, I think maybe the biggest win, and this isn't my legal analysis, but my political analysis, is the Republican presidential candidate field, all of whom were going to have to run directly to that King decision had it been in favor of dismantling the subsidies. Mm-hmm. But now, without anybody having to panic, without anyone having to spike the football watching American families suffer in reality, they get to go back to bashing Obamacare and bashing what they call an activist Supreme Court. That's exactly in their wheelhouse and perfect for them for the presidential campaign.
All right, I agree with you on that. Let's pivot back to the legal portion of this, though. What arguments do you think seem to prevail? This was a 6-3 decision, which is not as divisive as we've seen some other decisions at the court.
Well, the Fourth Circuit had said that the law was ambiguous and therefore had to be interpreted, could be interpreted by the IRS, because that's the way it works in all areas of the law. Is when there's an ambiguity, the agency set with enforcing it must interpret it. That happens on a state level every single day, and it happens at a federal level every single day. The Supreme Court took this case up because at the exact same time the D.C. Circuit Court had the exact opposite holding and said this is not an ambiguous statute. It's clearly designed only to give subsidies to state-run exchanges. So that conflict between the two circuits gave the opportunity for the Supreme Court to review it, and the Roberts Court, with the chief once again writing in favor of the majority to uphold the law, said that it is an ambiguous statute. Mm-hmm. It was not the most artfully written statute
right.
That Congress ever handed down, but it wasn't up to the IRS to interpret it. It's up to the courts. And since Marbury versus Madison, it's up to the courts to interpret the law. And he said it would be a ludicrous resolution to say that Congress's intent here on the basis of a couple of poorly placed words was to defund health care rather than to fund it.
And Justice Scalia, who wrote the dissenting opinion, had a different perspective on that. He thinks that this court has gone way beyond its boundaries with this, suggested that it be renamed SCOTUS Care is what he suggested that it be. What were the flaws, maybe, do you see in the legal arguments that were that he put out there?
Well, I don't know that there is necessarily a flaw on either side. I think it was well argued by both sides. It's just one was persuasive in the grander scheme. Chief Justice Roberts says that it's not up to them to interpret the surplus language of a statute without giving consideration to the totality. And it doesn't make sense for 4 words out of however many thousands of pages to be intended by Congress to invalidate the rest of the act. The dissenters say, well, maybe it wasn't intended, but that's how they wrote it, and they should be bound by the language that they wrote. So you see two kind of competing judicial philosophies there, but
in essence, a strict interpretation of what's written.
I think that Chief Justice Roberts would tell you that he gave you a strict interpretation of what was written. Chief Justice Roberts is a conservative. Now, right now, Rush Limbaugh and the like are out there saying that he's a disgrace to George W. Bush's appointment and that he's not a true conservative, which is the same kind of thing they used to say about Sandra Day O'Connor and so many others. He is a conservative, and he would say it's a strict interpretation, but it was done with some logic for the intent of Congress for the whole act. It's just that Alito and Scalia and Thomas would have written it much more narrowly and said, yeah, even 4 words can completely derail the entire act, and if it was up to them, that's what they would have done.
Do you see other legal challenges coming to this? Is this the end of the legal challenge road? There doesn't seem to be much talk of anything in the pipeline.
I don't think there's much left to fight. I mean, first of all, it's been fought twice. The same court has upheld it twice. 2 very solid, one constitutional and one statutory argument. Both of them were struck down. Millions of dollars spent and a lot of time and political capital expended. I'm not hearing anybody saying that it's time to get another case in the pipeline, because remember, you got to start at the district court and go up somehow. So it takes a couple of years minimum to get it there. In the meantime, we're going to have a presidential election that should take up all the oxygen on the debate.
Maybe Congress will pass a couple more laws and let the president veto them a few more times.
You know, Congress seems to be paralyzed, which is why their approval ratings continue to be so low. This could have all been avoided with a simple bit of corrective language, which I'm proud to say that our Republican-controlled legislature in Arkansas is not afraid to do. Every legislature does corrective legislation when they need to. Congress just can't seem to do it.
All right, he's Dustin McDaniel. Thank you very much for your contributions. Good to have you with us.
It's great to be back with you. Thanks.
All right, when we come back from this word from our sponsors, we're going to look at some other angles of this healthcare debate from a state political perspective and from what will happen next in the marketplace. Senator David Sanders and Marketplace Director Cheryl Smith are part of a roundtable discussion. We're back after this.